The envelope arrived on a Thursday from the county probate court. I almost threw it away. I had been getting court mail for 9 months. Estate notices, administrative letters, documents that required a signature, and then sat in a drawer. The ordinary paperwork of grief, I had learned to open them without feeling anything. I opened this one standing at my mailbox. It was a hearing notice. My father had filed a petition with the probate court to have me removed as co-executor of my mother's estate. The hearing was in 4 days. I read it twice in the parking lot of my apartment complex. Then I read the reason he had given the court for the removal. He had told them I was unreachable, that I had abandoned my executor duties. Despite repeated attempts to contact me, I had failed to respond. I had spoken to my father 6 days ago. We had talked about Thanksgiving. He had said nothing. I stood in the parking lot with the notice in my hand. And then I thought of something. This notice, the one I was holding, had my current address on it. The petition my father had filed used my old address. The address I had moved away from 14 months ago. One address got the original filing. A different address got the hearing notice. I was holding it because someone in the clerk's office had made an error. He had not expected me to know. He had 4 days before I would have had no recourse at all. I went inside. I called an attorney. And I started making a list of everything I didn't yet know. My name is Claire. I'm 29 years old. My mother, Ruth, died 9 months ago at 61. I want to tell you about her before I tell you about the court, because she is the reason any of this matters, and because understanding her is understanding the whole thing. My mother was the kind of person who thought about consequences before she acted. That's not a common quality. Most people act and then manage whatever follows. My mother sat with the decision until she understood its full weight. She could be slow in a way that frustrated my father, who has always been the opposite. Quick, certain, confident that moving forward is always better than waiting. Looking back now, she understood something about him that took me years longer to see. She had been a schoolteacher for 26 years. 4th grade. She had the particular patience of someone who has spent decades explaining things to people who don't yet have the context to understand them. She was patient with me. She was patient with my father. She was most patient about the things that mattered most. When I was 16, she sat me down and told me something she had never said before. She said, "Your father loves you completely. You know that." I said, "Yes," she said. "And he sometimes moves faster than he should. You know that too." I said, "Yes," she said. "When I'm not here, you'll need to know both those things at the same time." I said, "Mom, you're not going anywhere." She said, "I know, but I want you to have that anyway." I was 16. I filed it under the category of things parents say that feel abstract until they don't. Looking back now, she was preparing me. She had been a schoolteacher. She understood that some lessons had to be delivered before the test. My parents had a complicated marriage, not unhappily complicated. They loved each other in the real, accumulated way of people who have been through difficult things together. But they were opposite people. My mother moved carefully. My father moved fast. She thought about the consequences. He was confident that consequences could be managed. In 31 years of marriage, they had mostly made that work. The place it worked least well was money. Not because of dishonesty. My father was not a dishonest man. He was an impatient one. He made financial decisions quickly, without full consultation, with the certainty of someone who believed his instincts were reliable. Sometimes they were. Sometimes they weren't. My mother had told me once, early in my 20s, that she kept her own account, separate from the joint one. Not secret, she said, just hers. A record she controlled because controlling a record was important. She had said, "Your father and I have a wonderful life together, but I've learned to keep my own ledger." Looking back now, she had been teaching me the same lesson for years. In other words, until the year before she died, when she stopped using different words. She had her will drafted in January. She named my father and me as co-executors, equal authority. Both signatures are required for major decisions. She explained this to me directly, sitting at the kitchen table the month after she had the will prepared. She said, "I want you involved in every decision about the estate, not to watch your father, to be a partner. There are things he will want to move on quickly. I want someone there who will slow it down when it needs to be slowed." I said, "Mom," she said, "I'm a school teacher. I plan." She died 8 months later. And I had thought, I believed, that the co-executor arrangement was exactly what she had planned it to be. I did not know then that my father had been making decisions alone from the beginning. I did not know until the clerk's office made an error. 9 months of estate administration. My father had handled most of the paperwork. I had not questioned this. He was retired. He had more time. And in the fog of the first months of grief, I'd been grateful someone was managing the details. He had sent me occasional updates. Not frequent. Occasional. The utilities in the house are handled. The accounts are being consolidated. The attorney says things are on track. I had said. Thank you, Dad. Let me know if you need anything from me, he had said. I've got it. Don't worry. Looking back now, I was hearing reassurance. He was maintaining distance. The hearing notice arrived on a Thursday. Petition to remove co-executor due to abandonment of duties and failure to respond to repeated contact. I had spoken to him 6 days ago. He'd asked about Thanksgiving. I had said I was thinking of coming home. He had said, that would be nice. And I was holding a document that said I had abandoned my duties and failed to respond to repeated contact. That wasn't the worst part. The worst part was the date on the petition itself. He had filed it 7 weeks ago. 7 weeks. He had sat across from me at dinner 5 weeks ago and said nothing. He had called me 3 weeks ago to ask if I needed anything from the house. He had asked about Thanksgiving 6 days ago. 7 weeks of normal conversations. 7 weeks of a petition in the probate court that would have removed me from my mother's estate entirely. 4 days until the hearing. I went inside, and I started making calls. The first call was to a woman named Sandra Okafor, a state attorney. Referred by a colleague. She answered on the second ring. I read her the hearing notice over the phone. She said, "When is the hearing?" I said, 4 days. She said, "Okay. Are you named in the original will as co-executor?" I said, "Yes. Equally with my father," she said. "And you've been receiving estate communications?" I said. "Occasional updates from my father. Not formal court communications," she said. "Because he used your old address on the filing," I said. "Yes." She was quiet for a moment. She said, "Claire, I need to pull the full probate file before I tell you anything definitive. Can you give me 2 hours?" I said, "Yes." I waited. Looking back now, those 2 hours were the longest I had sat still since my mother died. Not from grief. From the specific feeling of understanding that something had been happening without you for months, and you were only now seeing the shape of it. Sandra called back in 1 hour and 40 minutes. She said, "I have the file." She said the petition cites 3 failed contact attempts. A letter to your old address in August. A letter to your old address in September. A phone call with no answer in October, to a number that, as far as I can find, is not registered to you. I said, "He has my current number." She said, "I know." She said, "Claire, the petition isn't just asking to remove you as co-executor." I said, "What else?" She said, "It's asking to be appointed sole administrator with full authority to liquidate and distribute estate assets without additional co-executor signature." I sat with that, she said. "Once that's granted, he can sell the house, close the accounts, and distribute assets entirely on his own. Without your agreement, without your knowledge." I said, "What's in the estate?" She said, "The probate file shows the family home, assessed at $214,000, and a joint savings account with a current balance of $41,000. I said, "Current balance." She said, "Yes." She said, "I want to ask you something. Do you know what the original savings balance was?" I said, "My mother mentioned 60-something thousand she had been saving for years." Sandra was quiet. She said, "The account shows 41,000 today." I said, "That's a difference of about 20,000, she said. "Yes," she said. "Estate accounts require co-executor authorization for withdrawals above a certain threshold. But if one co-executor was operating alone and the other wasn't receiving communications?" I said, "He's been making withdrawals," she said. "I don't know that. What I know is that the balance is lower than you expected, and the authorization records aren't in the file I have. I'd need the full account history," she said. "I can file an emergency objection to the hearing. It delays the proceeding and gives us time to request the complete account records," I said. "How long do we have to file?" She said, "I need to have it in by tomorrow morning. 1 day." I said, "File it." She said, "I need everything from you tonight. Every communication from your father about the estate. Every update, every text, every email. Anything that shows you were actively engaged, not abandoning." I said, "I have everything." She said, "Good." She said, "Claire, I want to prepare you for something." I said, "Okay." She said, "Your father is going to say he was trying to protect you. The estate was complicated, and he was handling it, so you didn't have to. That his intentions were good." She said, "That may even be true." She said, "It doesn't change what the filing says." That evening, pulling together every piece of estate communication I had received, I went through the box I had taken from my mother's house the week she died. A plastic file box. Her handwriting on the label. Important documents. The organized handwriting of a school teacher. I had opened it once when I was looking for her insurance cards. I had not gone through it fully. I went through it fully that night. At the bottom, under the insurance documents, under the copy of the deed, under the car title, was an envelope. Her handwriting on the front. To be opened with the will. I had never seen it. The will had been read by the attorney at the estate meeting. My father and I had both been present. Neither of us had mentioned this envelope. I did not know if he had seen it. I opened it. A single page. My mother's handwriting. Dated 3 months before she died. It read, David, I am leaving this with the will because I want it on the record. I have named Claire as co-executor because I trust her to slow things down when they need to be slowed. You know why I am saying this. I am not saying it to criticize you. I am saying it because I have been your partner for 31 years, and I know how you move. Please include her in every decision, not as a formality. As a partner. This is the most important thing I am asking you, Ruth. I sat at my kitchen table for a long time with that letter in my hand. My mother had written it 3 months before she died. She had put it in the box. She had labeled the box. She had trusted the right person to find it. And my father had been at the same estate meeting. He had seen the same box. He had said nothing about this letter for 9 months. I photographed every word. I sent it to Sandra at 11:47 that night. She replied in 4 minutes. She said, this goes in the filing. First page. Sandra filed the emergency objection the following morning. The hearing was stayed pending document production. The court ordered the full estate account history within 10 business days. My father called me that afternoon. His voice had the particular steadiness of a man who has realized the situation has changed and is deciding how to proceed. He said, Claire, I got a notice from the court. I said, I know. I filed an objection. Silence, he said. How did you get the hearing notice? I sent the petition to, I said. My old address, I know. He said, the clerk's office, I said. Made an error, yes. He said, Claire, I was trying to simplify things, I said. I know. He said the estate has been complicated. There have been decisions that needed to be made quickly. I didn't want to burden you with. I said, Dad. He stopped. I said, Mom left a letter. Silence. A longer silence than the one before it, I said. In the important documents box. In an envelope addressed to you, to be opened with the will. He said, I found that letter. I said, I know you did. He said, Claire. I said, I want to ask you something directly. He said, okay. I said, did you read it? The silence that followed was not the silence of confusion. It was the silence of a man deciding how much of the truth to give. He said, yes. I read it, I said. Then I'd like you to explain to me what happened between reading it and filing the petition 7 weeks ago. He said, it's complicated. I said, I have time. He said, can we talk in person? I said, yes. I said, but I want the account history first. He said, why? I said, because Mom wanted me to slow things down when they needed to be slowed. I said, consider them slowed. The account history arrived 8 days later. Sandra called me the morning it came in, she said. I have it. I want to walk you through it before you see it alone. That told me something before she said anything else. I said, okay. She said, the original savings balance at the time of your mother's death was $63,400. I said, that's what I expected. She said, the current balance is $41,200. I said, a difference of $22,200. She said, yes. She said, there are 4 withdrawals above the co-executor authorization threshold between months 2 and 6 of the estate. I said, 4. She said, all authorized by your father's signature alone. No co-executor countersignature. I said, can you do that? She said, no. Under the terms of the will and the estate administration agreement, withdrawals above $5,000 require both signatures. I said, what were the withdrawals for? She said, 2 are labeled estate expenses with no itemization. 1 is labeled property maintenance. 1 has no label at all. I said, no label. She said, correct. I said, how much was the unlabeled one? She said, $8,000. I sat with that. She said, Claire, I want to be careful here. These may all be legitimate expenses. Estate administration does cost money. Property maintenance is real. I don't want you to assume the worst before we have documentation. She said, but the authorization was not correct. And the petition to remove you, filed 7 weeks ago, came 2 weeks after the last unauthorized withdrawal. I said, he filed to remove me 2 weeks after an $8,000 unlabeled withdrawal. She said, yes. I said, Sandra, what happens to those withdrawals if I'm removed as co-executor? She was quiet for a moment. She said, they become internal estate decisions. No outside co-executor to question them, I said. They disappear into the record. She said, hey, become harder to challenge. I said, okay. I said, well, what do I do? She said, you come to court. She said, The stay hearing has been rescheduled. 3 weeks out. You appear. You object formally. You present the letter and the account history, she said. And you let the court decide what the authorization failures mean. I said, what does it mean for my father? She was careful. She said, at a minimum, he has to account for every withdrawal, itemize every expense, explain every decision made without co-executor authorization, she said. At maximum, she paused. She said, at maximum, the court may find that he breached his fiduciary duty as executor. That has legal consequences. I sat with the word fiduciary. My mother had used that word once. I hadn't understood it fully then. I understood it now. She had named me co-executor because she trusted me to slow things down. She had put in a letter. She had put the letter in a box. She had labeled the box. She had done everything she could from where she was. Now I had to do the rest. My father called again the evening before the account history arrived with me. He said, I want to explain before the court date. I said, okay. He said, the withdrawals are legitimate. Every one of them. The estate expenses were legal fees I paid out of pocket initially and reimbursed myself. The property maintenance was the roof. There was a leak, and it needed emergency repair. I made a fast decision because waiting would have cost more. He said, the unlabeled one. He stopped. I said, $8,000, Dad. He said, I know. I said, no label. He said, I know. I said, what was it for? He said, I needed to cover something personally. Temporarily. I intended to replace it. That sentence sat between us on the phone line. I said, you used estate funds for a personal expense, he said. Temporarily. I was going to replace it, I said. Does the estate account show the replacement? He said. Not yet. I said. How long ago was the withdrawal? He said. 4 months. 4 months. My mother's money. Sitting in my father's account for 4 months. Not replaced. Not lay-placed. And 2 weeks later, a petition to remove me from the estate entirely. I said, Dad, I need you to hear something. He said, okay. I said, Mom left a letter because she knew how you move. She said it herself. She wasn't criticizing you. She was protecting the estate. She was protecting me. He said, I know. I said, and the first thing you did when the administration got complicated was to file papers to remove the one person she specifically put in place to slow you down. He said, it's not what I was. I said, I know it wasn't what you were trying to do. I said, but it's what you did. He didn't answer. I said, I'll see you in court. Have you ever had to say something to a parent that you knew was true? And true in a way that was going to hurt them? And said it anyway because it needed to be said? If you know that weight, type "inish" in the comments. Because what happened in that courtroom is something I was not prepared for. 3 weeks. Between the account history and the court date. 3 weeks of being in the same family as my father while knowing what I knew. My aunt. His sister, Patrice. Called me in the second week. My father had called her first. She said, Claire, your father is very upset. He says this is going to tear the family apart. I said, Aunt Patrice. Did he tell you why I filed the objection? She said. He said you were upset about not being included in estate decisions. I said. Did he tell you about the account withdrawals? A pause. She said. He mentioned there were some accounting questions. Izady, that there are 4 withdrawals made without co-executor authorization. One of them, $8,000, is labeled as a personal loan to himself that he hasn't repaid. Silence. She said. I didn't know that. I said. I know you didn't. She said. Are you going to have him arrested? I said. I'm going to court to protect my role in my mother's estate. What happens after that depends on what he tells the judge. She said. Claire. He's your father. I said. I know. I said. Mom named me co-executor because she trusted me to do this. I'm doing it. She was quiet for a moment. She said. She always said you were the one who understood consequences. I said. Yes. She said. I'll stay out of it. I said. Thank you. I went home and sat at the kitchen table with the letter. My mother's handwriting. 3 months before she died. Please include her in every decision. Not as a formality. As a partner. This is the most important thing I'm asking you. What do you think I felt sitting in that courtroom waiting for the hearing to begin? Option A, anger. The kind that makes you certain and focused. Option B, grief. Because this should never have been a courtroom situation. Option C, something quieter than both. The feeling of carrying out someone's instructions when they can no longer carry them out themselves. Drop your answer in the comments, because what happened when my father walked in and saw me sitting there is something I still think about. The night before the hearing, my kitchen table. The letter was there, photographed and submitted to the court already. Sandra had filed it as Exhibit 1, but I had kept the original with me. The paper my mother had touched. Her handwriting was in the specific way she wrote letters, slightly forward-leaning, deliberate. Your father sometimes moves faster than he should. You know that too. She had said that to me when I was 16. She had said it again in this letter. She had been consistent. She had been a school teacher. She repeated the important things until they landed. I thought about the 9 months since she died. The occasional updates from my father, the reassurances. I've got it. Don't worry. Looking back now, every reassurance had been a door closing, not cruelly. He was not a cruel man. He was an impatient one who had been moving at his own speed through a complicated estate and had found it easier to manage alone than to slow down for a co-executor who was grieving and far away. He had not planned to steal from her estate. He had borrowed from it and planned to replace it. He had planned to remove me quietly and continue. He had not planned for a clerk's office error. He had not planned for the box labeled important documents. He had not planned for a letter his wife had written 3 months before she died that had sat at the bottom of that box waiting for the right person to find it. My mother had planned for all of it, not for the specific events. For the principle, she had left a record because she understood that records outlast the people who make them. I had found the record. The tears came quietly. Not a collapse. The quiet overflow of a person who is tired and certain at the same time. I cried for my mother, who had been patient her whole life and had spent her last months making sure the patience would count for something. I cried for the version of the 9 months that should have happened. My father calling me when decisions needed to be made, the two of us moving through the estate together, her wishes honored by the 2 people she had trusted. That version was gone. This one was tomorrow. I put the letter in my bag, set my alarm, and went to bed. The hearing was at 10 in the morning. I arrived at 9:15. Sandra was already there, files organized, composed in the way of someone who has been in courtrooms enough that they no longer carry the particular tension of first-timers. She said, "He's going to see you, and he's going to recalibrate. He came here expecting a formality. He's going to have to think fast." I said, "Okay," she said. "Let me lead. If the judge asks you directly, answer directly. Don't qualify." I said, "Okay." My father walked in at 9:52. He was wearing a suit. I had not seen my father in a suit since my mother's funeral. He saw me before he saw anyone else. He stopped in the doorway. 3 seconds, maybe 4. Then he walked to his seat. His attorney leaned to him immediately, speaking quietly. My father shook his head once. The hearing opened at 10:03. The judge, a woman 60-something, with the particular calm of someone who has heard every version of every family situation, reviewed the filings before speaking. She said, "This is a petition to remove the co-executor. A timely objection has been filed by the named co-executor. We also have a request for an accounting review of estate disbursements. Is the petitioner prepared to address both?" My father's attorney said, "Yes, Your Honor." She said, "I have a letter here, submitted as Exhibit 1, authored by the decedent." She looked at the page. She said, "The decedent specifically requested that the co-executor be included in, quote, every decision. Not as a formality. As a partner." She set it down. She said, "Can someone tell me when the co-executor was last consulted on an estate decision?" My father's attorney said, "We would argue that repeated attempts to contact." The judge said, "I'm asking when she was last consulted on a decision. Not contacted. Consulted." Silence. The attorney said, "We would need to review the records." The judge said, "I'll wait." The silence in that courtroom lasted approximately 40 seconds. Then my father said, "May I speak directly, Your Honor?" The judge said, "Please." My father stood up. He said, "I made decisions without my daughter's full involvement. I told myself it was because I could move faster alone. Because the estate needed decisions and I was capable of making them." He said, "My wife asked me not to do that. She asked me in writing, which is in your exhibit. And I did it anyway." He said, "I filed the petition because I didn't want to be questioned about decisions I had already made. Not because Claire had abandoned anything." The courtroom was very quiet. He said, "I'm withdrawing the petition." Sandra did not move. The judge said, "And the accounting questions?" He said, "I'll provide full itemization. The personal withdrawal will be replaced within 30 days. He said, "With interest." The judge said, "I'll note the withdrawal and the commitment on the record. Co-executor status for Claire Hartley is confirmed. This matter is closed pending the accounting submission." She closed the folder. My father sat down. He did not look at me. I looked at him. I did not feel what I had expected to feel. I had expected something that felt like winning. This felt like something else, something quieter, something that looked, from certain angles, like grief. The consequences settled over the following weeks like weather after a storm. Present. Heavy. But no longer dangerous. My father submitted the full itemization within 2 weeks. The legal fees and roof repair were legitimate. Documented. He had paid them and reimbursed himself, which was allowable under the estate agreement with the correct authorization, which he had not obtained, but which Estra negotiated as a retroactive acknowledgement given the legitimacy of the expenses. The $8,000 withdrawal, the unlabeled one, was replaced in full within 21 days. With interest, as he had said in court. The account balance was restored. My role as co-executor was confirmed in writing, and my father called me on a Thursday evening, 3 weeks after the hearing, and said something I had not expected. He said, "I want to tell you something. Not an explanation, just the truth." I said, "Okay." He said, "I found your mother's letter in the box the week after she died. I read it, and I put it back." I said, "You put it back?" He said, "Yes." I said, "Why?" He said, "Because it told me what she already knew about me, and I wasn't ready to be the man she was describing. I thought if I moved through the estate quickly, if I made the decisions and handled it cleanly and it was done before anyone could question anything, I wouldn't have to be that man." I said, "The man who moves too fast?" He said, "Yes." He said, "I've been that man for 64 years. I didn't want your mother's death to be the place where it finally caught up with me." I said, "It wasn't her death. It was her letter." He said, "Yes." He said, "She knew me completely." He said, "And she trusted you to do what I couldn't." I said, "Dad?" He said, "Yes." I said, "She trusted both of us. She named both of us. She wanted it to be both." He said, "I know." He said, "I'm sorry I made it a courtroom instead." I said, "I know." And my Aunt Patrice, who had stayed out of it as she had promised, called me the weekend after the accounting was submitted. She said, "Your mother would have had something to say about all of this." I said, "What do you think she would have said?" She was quiet for a moment. Then she said, "I think she would have said, 'I told you so.' And then she would have made coffee and moved on." I said, "Yes, that's exactly what she would have done." I went back to the house in November, not to sort through anything, not for a specific task, just to be there. My father was there. He had been staying in the house while we worked through the estate, a decision I had agreed to in writing as co-executor. One of the first formal decisions we had made together. He made coffee. We sat at the kitchen table, the same table where my mother had told me, when I was 16, that my father sometimes moved faster than he should. The same table where she had sat for 31 years of marriage, patient with the man across from it. We didn't talk about the court. We talked about the house. What should be done with it? Whether to sell now or wait for the market to move. Whether there was anything in it either of us needed before the estate was settled. That. It was the conversation we should have been having for 9 months. It was slow. It was the right speed. My father said, "She had a way of making a table feel like a negotiation." I said, "She was a school teacher for 26 years. He said, "Yes." He said, "She was patient with everyone. But she was most patient with the things that mattered most to her." I said, "Yes." He said, "I was one of those things. For a long time." He said it the way my father rarely says things, without looking for the polished version, just the accurate one. I said, "You still are." He said, "I made a mess of the estate." I said, "You're making it right." He said, "She would have had thoughts about the method." I said, "She left the thoughts in writing." He said, "Yes, she did." He looked at the table for a moment. Then he said, "I'm glad the clerk made an error." I said, "Me too." He said, "I was going to fix everything quietly and no one would ever have to know." I said, "But he would have known somewhere." He said, "Yes." He said, "She always knew." I drove home that evening with the letter in my bag. Original. My mother's handwriting, still slightly musty from the box. I put it on my desk when I got home, under a glass paperweight she had given me years ago. Clear glass with a small dried flower suspended inside it. She had bought it at a craft fair when I was 10. She had said, "I thought you'd like having something that keeps a thing exactly as it was." I had not known then what she meant. I understood now. The letters under the paperweight. I can see them both from where I'm sitting. It's a morning in December. The paperweight is on my desk. The letter underneath it. Coffee on. My father and I have had 4 estate meetings since the hearing. Formal. Scheduled. Both signatures on every document. The right speed. The right process. The house will go on the market in January. My mother's savings, fully restored, will be distributed according to the will once the estate closes. Everything she planned will happen the way she planned it. A little later than she expected, with more detours, but correctly. Here is what I have been thinking about since November. My mother was a school teacher for 26 years. She knew something about preparation. She knew that the lesson has to be delivered before the test. She knew that some things can't be planned in the moment. They have to be placed in advance, waiting for the right moment to land. She told me at 16 that my father sometimes moves too fast. She said it again in a letter 3 months before she died. She put the letter in a box she labeled clearly. She named me co-executor because she trusted me to use what she had taught me. She could not control what came after. She could not control whether my father would honor the letter. She could not control the 9 months of estate administration, the withdrawals, the petition, the hearing. What she could control was the preparation, the lesson delivered before the test, and when the test came. When the envelope was received from the county probate court on a Thursday morning by the clerk's office, I had everything she had given me. The words she had said at 16. The letter in the box. The knowledge that some things need to be slowed down. I walked into that courtroom because she had spent 31 years making sure I would know how. My father withdrew the petition because somewhere in his 64 years of moving fast, he had married a woman patient enough to prepare for exactly this moment. The glass paperweight is on my desk. The letter is underneath it, kept exactly as it was. That's what she would have wanted. That's what I have. Has someone ever prepared you for something in advance without telling you it was preparation, that you only understood when you needed it? And have you ever had to protect something for someone who was no longer there to protect it themselves? Tell me in the comments. I read everyone. Type letter if this story stayed with you. Subscribe to everyone. A new story every day. Check the description for more. I'll see you tomorrow.